So Colorado water law dates back about 160 years. When the first colonial settlers on the east coast of America arrived, they incorporated the British common law water law, which is the riparian doctrine. And it says that people who are living on the banks of the river have the right to use the water, provided they don't diminish the quantity or the quality significantly. But when the first settlers got to Colorado, they realized that just having the water in the stream wasn't going to succeed, that it needed to be moved out of the stream and onto the land to irrigate crops and supply municipal needs. So the earliest territorial legislatures actually authorized diverting water out of the river and using it on ground that wasn't adjacent to the stream. And then in 1876, when Colorado became a state, and the Colorado Constitution was adopted, it became the foundation for the modern water law. So our Constitution says that the water of every natural stream is the property of the public. That is, you never can own water, but you can obtain the right to use it through appropriation. And it says the right to divert unappropriated waters can never be denied. And finally, the Constitution provides the priority of appropriation will give the better right between those using water for the same purpose. This is the prior appropriation doctrine. So this is known as first in time, first in right. So what is in prior appropriation? Prior means that the earlier water right decrees, which we call the senior rights, in times of short supply can fill their complete need before junior water rights, that is later water rights, can begin to use the water. Appropriation requires an intent to make an appropriation, and then diverting the water from the natural stream with some exceptions, applying the water to beneficial use without waste. Now, there are 4 exceptions to the need to divert water from the natural stream. One of them is impoundment or storage. You can obtain a water right for storage, which we'll talk about in a few minutes. In-stream flows, which the state of Colorado can appropriate to protect the natural environment to a reasonable degree. Recreational in-channel diversions, which are essentially water parks, which certain entities, municipalities can appropriate and leaving the water in the stream. And finally, hydropower. Generating hydropower is not consumptive and it doesn't require removing the water from the stream. Once you've appropriated water, you've got to protect that water right through adjudication. And adjudication occurs in the water court. And in the water court, the applicant has to demonstrate that the water is available both legally and physically at the point of proposed diversion, and then a decree can be obtained. And we'll talk about the process in a minute, but the decree confirms the priority. It confirms the source of supply, the amount of the water right. It establishes the point of diversion from the natural stream. It defines the type of use and the place of use, and it includes conditions to protect against injury to other water rights. So the process for adjudicating the water right is that you begin by filing an application in the water court. We have 7 water courts, and each of the main water basins around the state. Gunnison River Basin is Water Division 4. And so then the clerk of the water court will publish the application in the water court resume, which is published online and in some cases in local newspapers to give notice to the public of the fact that a person is attempting to obtain the right to divert the water. At that point, any interested party can file a statement of opposition stating reasons why the water right shouldn't be granted or proposing conditions that should be placed on the water right to avoid injury to other water rights. Then there is a judicial officer called the water referee, and he performs an investigation of the facts that are asserted in the application that's been filed in the water court. And then he turns to the division engineer for on the ground verification of the facts that are asserted in the application. The referee will then issue a ruling. And if the ruling is not contested, then the water judge will sign the decree and the water right is protected. This is an absolute water right, where the water is actually taken from the stream and applied to the beneficial use without waste. We also have conditional water rights. To get a conditional water right, the applicant doesn't have to take any water out of the stream. So why would we have a conditional water right where there's no water appropriated? Well, this is to enable the development of the resource. When you have a major project that takes many years for design and engineering and construction, it needs to have a way to protect its water right, so that when you file the application for a conditional water right, it establishes the priority of the water right. And that's important when you have these big, expensive projects. This is an example is the Frying Pan, Arkansas project, a very large, complex, expensive project. It took more than 20 years to build that project. So the water right priority was protected during that construction process, so that when the investment is made and the construction is complete, the applicant knows that it has a water right that has a priority that's useful. So to obtain a conditional water right, there has to be a first step, an overt act. For example, the board of directors of the Upper Gunnison River Water Conservancy District will have to direct the manager to begin work on filing a water right application. That's an overt act. Then that act has to be followed by showing the intent to appropriate the water. In other words, we are going to define our project and say, this is how we're going to take the water and how we're going to use it. And then have to continue to demonstrate the fact that the water is going to be appropriated in a reasonable time. Just like an absolute water right, the notice has to go out in the resume to give notice to the interested parties and allow them to oppose or demand conditions. And then the applicant has to show a substantial probability that they can and will complete the appropriation. You can't preserve a conditional water right indefinitely without showing some progress toward the actual appropriation. And you have to come into the water court every 6 years and demonstrate that the applicant is diligently pursuing the actual appropriation of water. Storage rights. So one can obtain a water right to store water. That is to take the water of the natural stream, either on stream or off stream, and have it for later application to a beneficial use. Well, a few years ago, there was a challenge to storage water rights saying, well, if you fill up that reservoir, but then you don't empty it during the year, you're abandoning part of your water right. So the legislature changed the statute to say that storage can be carried over from year to year. So the holder of a storage right doesn't have to empty the reservoir every year to preserve the total water right. But generally speaking, the reservoir can be filled one time each year with the decreed amount of water in priority. And then in addition, if the applicant obtains a decree for a refill right, you can empty the reservoir and then refill it, still in priority, provided that you've obtained this refill right in the decree. Well, we have a popular myth in Colorado called use it or lose it. And we hear people in the press always talking about, if we don't divert the whole amount of the water, we're going to lose the water right. Well, that's not actually true. For an absolute water right, there has to be non-use for an unreasonable period, and the holder of the water right has to have an intent to abandon. An intent, obviously, is a subjective standard, and it is evaluated on a case-by-case basis by the water court. Every 10 years, the division engineer is required to examine the water rights within his jurisdiction and determine if a water right has been unused for an unreasonable period of time, and then he publishes an abandonment list. And that list is made public, and anyone whose water right appears on the list has the right to protest in the water court. And the water court can determine that, in fact, the water right holder did not have the intent to abandon, and the water right will be continued. Well, with a conditional water right, it just means that they have not met that reasonable diligence test. In other words, nothing is happening to progress the project toward the actual diversion and appropriation of the water. Water rights can be changed. We can change the type of use, we can change the place of use. And the way that is accomplished is to file the application in the water court, and the process is exactly the same as the original appropriation. You file the application, the application is published in the resume. Any interested party can file a statement of opposition to say it should not be allowed, or that it place conditions on the change to protect other water rights. And then it goes through the same process with the referee, the division engineer, and ultimately there would be a decree issued by the water court authorizing the change. The principal standard for the water court in evaluating changes to water rights is that it doesn't cause any injury to other water rights. The other thing about a change, if it's a change of the type of use, especially, the only amount of the right that can be changed is the amount of consumptive use. That is to say, if you divert 100 CFS, but the crop only consumes 50 CFS, then that is the amount of consumptive use, and that's the only amount that can be changed. The remainder has to be left in the stream or returned to the stream so that it doesn't cause injury to any other water rights. Another thing that is commonly occurring now, because all of our river basins, and the Gunnison River Basin especially, is over appropriated. That means that there are more water rights decreed than there actually is water available to divert at all times. In dry years, some water rights may not be able to divert at all because their priority is so low. So what can you do to protect a water right that has a junior priority but is essential? This is an example of a schematic, very rough. I apologize, I'm not much of an artist. A plan for augmentation that the Upper Gunnison District participated in. We have municipal wells in Lake City, and their priority is very junior. The wells have been there for a long time, but the city didn't file water right applications until very late. So we have downstream senior water rights, the Gunnison Tunnel, which is a very senior water right, but also some senior irrigation rights, and the Water Conservation Board has an in-stream flow water right in the Lake Fork. So here we have Lake San Cristobal, the Lake Fork of the Gunnison River, Blue Mesa Reservoir. Now, we had some discussion earlier about a call on the river, and that is, and Lisa gave a very good definition. So if the senior water right, for example, the Gunnison Tunnel, is not able to divert its entire decreed amount, it can place a call on the river, and it contacts the division engineer and says, I'm not getting my full water right. I want you to curtail all the junior water rights. So how do we keep these wells in priority when the Gunnison Tunnel places a call? The Upper Gunnison District acquired water in Blue Mesa Reservoir, and it can be released from the reservoir to satisfy the tunnel and maintain the diversion by the Lake City wells. Well, that's fine if the call just comes from the Gunnison Tunnel, but what if a senior water right in the Lake Fork or the Water Conservation Board places a call to protect its in-stream flow right? In that case, Blue Mesa doesn't help. So we have obtained a decree to store water in Lake San Cristobal, and it can be released to satisfy the call of the in-stream flow right in the Lake Fork, or to satisfy a call by a senior irrigation right. Plans for augmentation are obtained through the same process as any other water right. an application is filed in the water court, and it goes through the same adjudication process that an application for a water right or a change of water right occurs. And that's basic Colorado water law 101. And I'm happy to take any questions. I can't see the other participants right now, so
Thanks,
I don't
John.
know if there are hands or not.
Yeah, who's got a question? Brennan, go ahead.
John, you didn't mention diversion control, but the assumption is that diverters or folks asking for a right have a means and methods to control the diversion they're proposing, correct?
That's correct. I think Bob's going to talk about that in some detail.
Okay.